everyone, welcome back. It looks like most people are back from the break, so we're going to go ahead and get started with the second half of the symposium. I hope you guys enjoyed those first couple speakers as much as I did. I know they were really wonderful. Hopefully you've had a chance to stretch your legs, grab something to drink during the break, and are ready for the second half, which I think is going to be just as interesting as the first half of this has been. So my name is C.A.R.E.S, and I'm the director of the Union County Family Justice Center. It's my pleasure to introduce to you our next two speakers, Michelle Lefkowitz and Teresa Hilton. They will be jointly presenting on a more practical side of the topic we've been focusing on today, how to secure a firearm from a domestic abuser. Teresa is the head of the Domestic Violence Unit at the Union County Prosecutor's Office. In her role, Teresa reviews all criminal domestic violence complaints, reviews the plea offers, briefs, and correspondences created by the unit's assistant prosecutors, and serves as a tremendous resource and expert on domestic violence policy and prosecution for the office and county police departments, as well as here at the Family Justice Center. Michelle is the director of legal programs for Partners, formerly known as Partners for Women in Justice, a nonprofit organization that advocates in the courts and through policy for victims of domestic and sexual violence and their children. Since joining Partners 10 years ago, Michelle has helped hundreds of victims obtain final restraining orders, custody of their children, and financial stability through awards of child and spousal support. Michelle leads an excellent team of staff attorneys and paralegals that provide high-quality legal advocacy for all of Partners' clients, some of whom are shared clients here with the Family Justice Center. Michelle not only advocates in court, but has also done significant work in helping to affect systemic change in policies that impact the safety, well-being, and the quality of life for all survivors here in New Jersey. Without further ado, here are Michelle and Teresa.
Good afternoon. I'm Teresa Hilton, the supervisor of the Domestic Violence Unit at the Union County Prosecutor's Office. And here with me is Michelle Lefkowitz.
Hi, everyone. I'm the director of legal programs at Partners.
And today we're talking about the ways in New Jersey that firearms can be removed from abusers. In this state, there are 4 different mechanisms to do it. The first is obtaining a restraining order under the Prevention of Domestic Violence Act of 1991. The second method is that as part of a police response to the report of a commission of act of domestic violence, there's a method for them to take firearms from a potential abuser. The third is if an individual is convicted of an offense or a crime of domestic violence. And the fourth is the red flag law of New Jersey, a court order issued pursuant to the Extreme Risk Protective Order Act of 2018, which I will call in shorthand an ERPO. But starting first with the restraining order, I'm going to pass it to Michelle, who is the expert on that.
Thanks, everyone. So a domestic violence restraining order is one way to remove guns from an abuser. The restraining order process in New Jersey is a 2-step process. The first step is to get a temporary restraining order, which is issued by a judge on application of the victim. The defendant is not there. This restraining order can be obtained either by going to the county family court or by accessing the municipal courts through a local police precinct. But in either case, it's issued by a judge, either a superior court judge or a municipal court judge. The standard for getting a temporary restraining order is good cause that the victim's life, health, or well-being are endangered by the abuser's acts of domestic violence. That is a relatively low standard. So a temporary restraining order is meant to stay in place only until a final restraining order hearing can be obtained or a voluntary dismissal by the victim. The idea is to provide immediate temporary protection in the moment, and then the court will have a much fuller hearing at the final restraining order stage. That final restraining order stage is supposed to be scheduled within 10 days of the issuance of the temporary restraining order. While the temporary restraining order is obtained without the defendant on an ex parte basis, a final restraining order is a very different hearing. It is a bench trial with presentation of evidence and witness testimony. Both the plaintiff and the defendant have a right to be present and to present their case, with the victim going first and bearing the burden of proving the elements necessary. A final restraining order, once issued, will not expire. That's something that is unusual. In most states, a final restraining order will expire after a period of time. In New Jersey, that's just not the case. It will stay in place until further order by the court. And that means that many, many restraining orders in New Jersey will stay in place forever. So now we're going to talk about the protection that can be obtained at the temporary restraining order stage, at that first stage before the full hearing. There are many options for protection that a judge can issue at that time. And the first is to forbid the abuser from possessing any firearms or weapons. That can happen at the temporary stage. Whether or not that restriction continues will be determined at the final restraining order hearing, but any weapons can be seized at the temporary stage. Requiring the abuser to stay away from the victim's home, workplace, and other identified locations. We call this a keep away order. It means that the abuser must stay away from the victim, can make no attempts to get near the victim or to approach or contact the victim. This is for the protection of the victim and to avoid witness tampering. The court can also grant the victim exclusive possession of a shared home. That means that if the parties lived together before the temporary restraining order was issued, often the courts will allow the victim to stay in place, and the police are then obligated to remove the defendant from the home so that the victim can stay in place. That is one of the possibilities. It's not the only possibility. Some victims choose to leave, and that's up to them. They may go into shelter, they may flee to a family member's home, but they typically, if they want to, have the possibility of having a judge allow them to stay in the shared home until the process is resolved. So again, this is at the temporary stage. That's not a permanent determination. It's really just to allow the victim to stay put until the final hearing. Forbid the abuser from contacting the victim, victim's relatives, or individuals at risk because of their relationship to the victim. This is what we call just generally the no contact provision. And this is really meant to prevent any kind of intimidation, any kind of contact at all. It's not just harassing contact, it really is any contact. When there's a restraining order in place, it is a crime for an abuser to contact the victim. The additional individuals that can be listed on the restraining order are generally people who are close to the victim or have close contact. That's something that can be requested and a judge can add. It's common for example, if a victim has children that are not shared with the abuser, those children are typically added as what we call protected parties, so that there can be no contact with them as well. This forbidding of contact is by any means. So it's direct, face to face, phone, email, text, but it's also third party communication is prevented. That means that an abuser is not permitted to try and reach out to the victim through a family member, a friend, or anyone else for that matter, even if that other person is not protected on the restraining order. The indirect communication is also prevented. Forbid abuser from going to the victim's workplace. This is actually something that does happen a lot where abusers will try and find the victim or intimidate them at their workplace. It's really just for general safety. Grant temporary custody of children and suspend visitation. This is when there are shared children between the parties. When they have children in common, it is a safety precaution to grant custody of the children to the non-abusive parent. That's the victim in the case. And to suspend the visitation of the abuser. And this is because the goal of this order is to provide immediate protection. And one way that abusers and victims, when they share children, can come into contact is during a visitation drop-off or pickup. And that is a very dangerous circumstance. So the court can just suspend that entirely for the period that the temporary restraining order is in place. And the custody of the children is to also avoid any issue with the shared children and between the parents so that they do not have to interact regarding the children during this time period, which is considered a very dangerous time. When a victim leaves an abusive relationship, that is the most dangerous time during the relationship. And so the goal here is to cut off any form of contact and to avoid the possibility of using the children as pawns in the process. And the final thing on the list is emergent financial support. That is truly emergent. These are not orders that are going to stay in place for a lengthy period of time. They are designed just to carry the victim through the process until the final restraining order hearing. It could be the financial support can be in the form of child support. It could be a one-time payment, or it could be set up as a weekly payment. Another option that we see a lot is where if the temporary restraining order is going to cross the first of the month, judges will sometimes order that an abuser pay their rent. Again, this is very short term. This is very temporary. It's only until the next hearing. Now, there are additional protections that are available when a final restraining order is issued. All of the protections available under the temporary restraining order are typically continued into the final restraining order if the final restraining order is granted. That means that there is continuation of the rule against possession of firearms or weapons. And it can also include continuation of some of those other remedies. Typically, the no contact and the keep away would absolutely continue, but the court may revisit some of those other protections, such as suspending visitation and things like that. So, specifically at the final restraining order stage, the abuser can be required to pay the victim back costs that are associated with his or her out-of-pocket expenses due to the domestic violence. This could be medical care for injuries or repairs of something damaged during the incident of domestic violence. Often that would be cell phones, which are commonly broken during incidents of domestic violence, but it can be other things. It could be, we've seen cases where victims' glasses were broken, things like that, really any out-of-pocket costs. Also, that can be ordered is Batterer's Intervention Program. That is a 6-month program designed to treat and rehabilitate domestic violence abusers and help them learn not to abuse. It's a 26-week program and it can be court ordered. A visitation risk assessment has to do with the visitation of shared children. It is a process by which the court will evaluate whether or not it's safe for the children to visit with the abusive parent. That is a process that the court engages in, and then there would typically be an additional hearing where a long-term decision on visitation would be made as a result of that assessment. And that leads us right into safe visitation arrangements. These can be done either at the entry of the final restraining order or after a visitation risk assessment, but the idea is to have protections built in to minimize the contact between the victim and the abuser at drop-off and pickup, as well as to ensure the children's safety during the visitations. Child and spousal support can also be ordered, and because our final restraining orders stay in place, this could be an order that continues on indefinitely into the future. It is still subject to change upon a change of circumstances, but here on this order, the court can order ongoing child support as opposed to emergent support. And they also can order ongoing spousal support if appropriate on this restraining order process. The child support would typically be paid through probation to avoid direct contact between the victim and the abuser. And it would be based on the court's assessment of the parties' incomes and abilities to pay, just like it would on any other docket. The next thing is substance abuse evaluation and treatment. If during the course of the final restraining order hearing, there's evidence that the abuser is struggling with substance abuse issues, the court can order the abuser to have an evaluation and or seek treatment for any substance abuse issues. While we know substance abuse doesn't cause domestic violence, it certainly can exacerbate situations and often plays a role in the abuse. The court can also order a psychiatric evaluation and treatment, which again, there would have to be some indication during the final restraining order hearing that there is a psychiatric issue that could be addressed through evaluation and treatment. and the court can order the abuser to undergo that process and to receive any treatment that the court thinks is appropriate through the final restraining order process. Punitive damages can also be awarded. This is relatively uncommon, but these are damages that are intended not to reimburse the victim for out-of-pocket costs, but rather to punish the abuser. It is certainly possible under our docket type, though it is somewhat uncommon, and it would require a showing that punitive damages are appropriate in the particular case. And attorney's fees. If the victim succeeds in obtaining a final restraining order, the court can order the defendant to pay reasonable attorney's fees that were incurred by the victim through the process. This can be done just by function of the statute, and it's something that sometimes victims will request, sometimes courts will just order on their own, but it can be obtained through this process if the victim is successful. So how do you get a restraining order? You can apply for a temporary restraining order at 2 Cherry Street, which is the family courthouse in Elizabeth. You can also access the family court by contacting the TRO helpline, which the information is on your screen right now, and the hours are there as well. There are individuals who are ready to handle the applications over the phone without the need for an in-person appearance, and that is accessible in English and Spanish. These emergent restraining orders during these business hours, you can go straight to the family court. You do not have to go to the police or to the municipal court. However, if you are seeking a restraining order outside of these hours, the only way to do that is to go through a municipality, and you can go to any municipality in where the victim resides or has fled and is sheltered, where the defendant resides, or where the DV actually occurred, if that's a different locality.
And just to add in there, if you're reporting a crime of domestic violence after hours, you can apply at the police station. It's a way to bridge the gap in protection between when you report the crime and when you get the protection of the restraining order.
Now, regardless of whether you get the protection issued by the Superior Court or the municipal court, it's the same protection. It stays in place until the final restraining order hearing. And at that hearing, anyone in New Jersey who wants a final restraining order will have to prove 3 elements. The first is that they have a qualifying domestic violence relationship. The second is that there was an act of domestic violence. And the third is that there is a need for protection going forward. Now we're going to talk about each of those elements. What is a qualifying domestic violence relationship? This is a designation by statute, and it refers to a spouse or former spouse, current or former dating partner, co-parent or expecting co-parent, or current or former household member. So these are domestic type of restraining orders. This is actually a jurisdictional issue. The court must find such a relationship in order to continue on with the process. So this is the first thing that has to be proven at your final restraining order hearing. Now, the dating relationship is something that can be a little complicated to determine if a relationship has crossed the line from initial communications into a dating relationship. It's a fact-specific inquiry that the court will make a decision on. Co-parent or expecting co-parent requires an actual current pregnancy or shared children. Current or former household member, that's any 2 people who have lived together ever. So it doesn't have to be a current roommate or a current partner that you live with. It can be someone you've ever lived with. For any one of these relationships, the abuser must be an adult, 18 years old or an emancipated minor, in order to get a restraining order against them. The victim, however, can be under 18 if it's a dating relationship. If it's any of the other relationships, then they have to be either an adult or an emancipated minor. So for the former household member, the victim would have to be an adult. For a dating relationship, the victim does not need to be an adult. But the abuser always needs to be an adult or emancipated minor. So the second thing you have to prove is an act of domestic violence occurred. That is called a predicate act, and it's an enumerated domestic violence crime. On the restraining order, there's a list of all of the crimes that can qualify as an act of domestic violence. The PDVA, Prevention of Domestic Violence Act, cross-references the criminal code here. So these crimes listed are exactly the same as you would have for a criminal case. However, because this is not criminal court, the victim only has to prove that it occurred by a preponderance of the evidence, not beyond a reasonable doubt. So, to distinguish the two, the preponderance of the evidence just means more likely than not. So, if you're weighing things and it's exactly 50-50, you have not met that burden. But if it's even slightly more likely to have occurred in the judge's estimation, then you have. You do not have to prove it beyond a reasonable doubt like you would if this were criminal court. But you do have to prove each and every element that is in the criminal code. So, of these acts, some of them are just more commonly seen than others. We frequently see, for example, assault, sexual assault, harassment, cyber harassment. These are very common crimes. Some of them are less common, but it's important to remember that that you do have to meet each and every element. So, for harassment, for example, you do still have to prove intent to harass. An interesting one on this list that I just want to highlight is contempt of a DV order. This is a relatively new act that was added to the PDVA. And this is important because if a temporary restraining order is violated by a defendant after they have been properly served with that order, you can add contempt as a new act, but that would as a new act of domestic violence that can support the entry of a final restraining order. That would typically have to be done by amending it because, by definition, it could not have been on the initial temporary restraining order. So I just want to flag that because it requires an extra step. Whether or not a final restraining order is granted on one versus another act does not matter. The restraining order is the exact same protection, whether it's granted on assault or harassment or anything else. So the court needs to find only one of these acts occurred in order to move on to the third step, which is a need for protection going forward. And that means that without the protection of a restraining order, there is a reasonable likelihood of ongoing abuse. This is an element that is forward looking. And so the way we prove that is by considering the seriousness of the current incident and the history of domestic violence. So while history of domestic violence is not required to get a restraining order, it is often considered as part of the assessment of whether or not there's a need going forward. And so it's important for victims to include on their restraining orders and for the courts to consider during the process.
So when a temporary restraining order is issued, often there will be an additional clause that the judge decides to check off or not. And it has to do with authorizing law enforcement officers to seize any handguns, firearms ID cards, permits to purchase, permits to carry. So if there's probable cause to believe that an offender has firearms or documentation to obtain one, the judge often and likely should authorize the police to search the residence or the location where they're stored and seize them. Now, in here, in this slide, I have a little asterisk that the standard required is probable cause. The statute, the actual domestic violence statute doesn't say probable cause, but by subsequent case law, that is required, and it is enforceable later down the road. So frequently asked questions that I get for restraining orders, and Michelle, feel free to jump in on any of this. I know some of this you've already talked about. The burden of proof is a preponderance. The defendant has to be served with a restraining order for it to be enforceable, or at least there has to be documentation that the defendant is aware of the restraining order. We cannot criminally prosecute somebody who has a restraining order entered against him or her, but that defendant isn't aware of it. It has to be a knowing violation. Prosecutors are not involved in obtaining a temporary restraining order or in a final restraining order hearing. Prosecutors come into play later if there's a violation of the restraining order. There's often confusion about the criminal charges and the restraining order process. They are not the same. One is a criminal case and the other is a family court civil case. So With respect to restraining orders and violations of them, they don't go both ways. The victim cannot violate his or her own restraining order. It only applies to the defendant violating the restraining order. Um, and with respect to the restraining order, a victim can contact the family court and withdraw or ask to dismiss the restraining order. It doesn't work that way with criminal charges. The state is the one who brings criminal charges, not the victim. Um, so while a victim has the power to drop a restraining order, the victim does not have the power to drop criminal charges that result from an act of domestic violence.
I just wanted to add here that the victim can drop either a temporary or final restraining order at any time by going to Superior Court. A defendant, however, can only dismiss a final restraining order upon a motion that actually has a high burden. So it's much easier for a victim to just go ahead and voluntarily withdraw the protections of the order.
And then the last bullet on here, and this is also something that's fairly new to the statute, is the if a victim is denied a temporary restraining order, the victim has an immediate right to an appeal to a superior court judge. So, for example, let's say it's after court hours and the victim has gone to a municipal police department, reported an offense or crime of domestic violence, and then decides to apply for a restraining order. And the municipal court judge listens to the application and denies it. That victim can decide then and there to immediately appeal to an on call superior court judge who will hear the evidence again and review it fresh and make an independent decision on whether or not to grant or deny that temporary restraining order. And the last thing, Michelle, you already talked about, there's no expiration on a final restraining order in New Jersey. All right, so this is the second bullet that I had mentioned in that second slide with the 4 different ways to remove a firearm from an abuser in New Jersey. This is a less obvious one. Under the domestic violence statute, if a law enforcement officer responds to a report of domestic violence and the law enforcement officer has probable cause to believe an act of domestic violence has been committed, the officer must ask everybody there whether there are weapons on the premises and seize any weapon that the officer reasonably believes exposes the victim to a risk of serious bodily injury. This, by the way, isn't limited to firearms, but since that's the subject of this presentation, I'll focus on that. So, if a law enforcement officer is responding to a scene on a domestic violence report and the officer has probable cause to believe a domestic violence offense or crime has occurred, that officer has an obligation to ask if there are weapons present that present a continued risk to that victim and then take them. Now, there's paperwork that the officer will file after that I'll get into a little bit later. It's a similar process here as it is when weapons are seized from a restraining order, about what happens to them from there. Um, and I just want to highlight that information is coming. I'm not going to focus on it yet. But there is a subsequent hearing that takes place that prosecutors are involved in how to dispose of the weapons that are taken either under a search warrant provision for the restraining order that Michelle just talked about, or when the officer has responded to an incident of domestic violence and has seized weapons that present a risk to the victim. Well, here's my next slide. So, what happens is when those weapons, firearms for the purposes of this presentation, are seized, the officers have to document what's taken and provide paperwork to the defendant and to the court so that a weapons forfeiture hearing is initiated. The court and the prosecutor's office, because the prosecutors are the ones who handle these. So, what happens then is there is a process by which the state can either return or the court will order the return of those weapons or not. There can be conditions set before they're returned, or the weapons can be seized indefinitely. What the court is going to determine when one of those firearm forfeiture hearings is initiated is what's included in this slide. Is the owner subject to any disability set forth in the statute? So the statute that authorizes granting purchaser ID cards, permits to carry, there are certain things that disqualify somebody from being able to obtain firearms in the state of New Jersey. So before a seized firearm will be returned, the court is going to first make sure that that defendant is not disqualified by one of these factors. And that does happen where somebody who shouldn't have firearms obtains them, but through this process, it won't get them back. Either they came from out of state with the firearms, or they bought them at a gun show where they weren't doing the same background checks that you would expect to see at a licensed firearm store. All right. So first, before the firearms would be returned, they'd have to make sure that the subject is not barred because of one of the enumerated reasons under the statute. The second additional qualification, they'd have to make sure that whatever domestic violence complaint has either been dismissed at the request of the complainant, the victim, and the prosecutor determines that there's insufficient probable cause to indict, or defendant is found not guilty of the charges, or the court determines that domestic violence situation no longer exists. So what that means is the complaint has been dismissed at the request of the victim, and the prosecutor has not gone forward on the charges. Like I said, just because a restraining order is dropped doesn't mean that the charges, the criminal charges, are dropped, and they often aren't. So before those weapons are returned, the court would determine that the charges aren't going forward. Alternatively, if the charges go forward and the defendant is found not guilty of the charges and is not otherwise barred, the weapons would be returned. And then finally, there's a catch-all. So under circumstances where, let's say, the criminal charges fail for whatever reason, maybe the victim refused to testify, and so the prosecutor was unable to meet the burden at trial, or the case was handled in a place where the evidence just wasn't sufficient to go forward. But for some other reasons, there's evidence that the domestic violence situation is still present. If that's the case, even without those charges going forward, the court is not going to return those firearms. So before the firearms are going to be returned, seized either because of a police response to a domestic violence incident or because of the issuance of a restraining order, temporary or final, the court will return them if it's an eligible defendant and one of those three circumstances has been met, or all of those have been met. The penalties in New Jersey for violating these rules are severe. So the first statute I have here is going to be the statute that prohibits somebody from obtaining a firearm in the future because of either having a restraining order in effect, because a restraining order will also always bar the defendant from obtaining and possessing firearms. If somebody has a restraining order in effect, they cannot be given a purchaser ID card to purchase firearms. They're disqualified under the statute. Similarly, if the person has had an order barring that person from obtaining firearms under the Prevention of Domestic Violence Act, so that circumstance that I discussed above, where the domestic violence situation is continuing, but there are no charges present, that would be an automatic bar. But the court determines there's an ongoing risk and does not allow the return of those firearms. That order also would bar an individual from obtaining a firearm ID card. And if somebody barred from obtaining a firearm because they have a restraining order or they've been ordered not to possess them through a weapons forfeiture hearing, if they possess a firearm and are found to have possessed a firearm in New Jersey, they are a certain person not to possess firearms. That's under the criminal statute. So 39-7B, 2C:39-7B. Any person subject to a court order prohibiting the possession of firearms issued pursuant to the Prevention of Domestic Violence Act of 1991 who purchases, owns, possesses, or controls a firearm or ammunition is guilty of a crime of the third degree. There's exceptions for law enforcement or military members under certain conditions, but it's a third degree crime. And what's significant here is it's a Graves offense. So under the Graves Act, there are certain criminal violations that have more significant required prison sentences. So in this situation, this third degree crime has a minimum term of imprisonment of 42 months. So anybody who is prohibited from possessing firearms because of a restraining order or weapons forfeiture hearing, and they're found guilty of possessing a firearm later, uh, have a mandatory sentence of 42 months in prison. Now, the third situation where a firearm can be removed from an abuser in New Jersey is when that individual is convicted of a DV offense or a crime. And I say DV offense because that would be a disorderly person's offense or petty disorderly person's offense. And a crime would be an indictable crime, like a fourth, third, second, or first degree crime. So anytime that a defendant is either found guilty of a domestic violence offense or crime or pleads guilty to a domestic violence offense or crime, the defendant has to be advised by the court that that defendant is, from that point forward, prohibited from purchasing, owning, possessing, or controlling a firearm. They are ordered to immediately surrender to law enforcement any firearms or firearms ID cards or permits to purchase that they may have. And they are given an opportunity, a short window, to arrange for the sale of the firearm through a licensed dealer of firearms. But it's a very short window. It's 5 business days. And then the dealer has 10 business days to take possession. And then when that defendant pleads or is found guilty of the domestic violence offense, the judge warns that individual that a violation of that could result in new criminal charges. This is the form that is given to defendants upon being found guilty of a domestic violence offense or crime that basically delineates what I just said. So like I'd said before, where there is it's disqualifying if somebody has a restraining order or has been barred from receiving their firearms back through a weapons forfeiture hearing. That same statute, 2C:58-3, bars the issuance of a purchaser ID card or a permit to carry if an individual has been convicted of any crime or disorderly persons offense involving an act of domestic violence. So that is a disqualifier that would prevent somebody from ever getting firearms in this state. And similarly to somebody possessing a firearm with a restraining order, somebody who possesses a firearm who has previously been convicted of a domestic violence offense or crime is a certain person not to possess a firearm. And again, it's very similar to the language before. It's just a different underlying reason why they're barred from possessing them. But a person having been convicted in this state or elsewhere of a disorderly person's offense involving domestic violence or a crime involving domestic violence who purchases or possesses or controls a firearm or ammunition is guilty of a crime, third degree, with, again, the exception for law enforcement and military members. So the minimum term of imprisonment in this circumstance is also 42 months. But it is worth noting that most of the enumerated domestic violence crimes that somebody can be convicted of elevates this statute to a second degree violation, a second degree crime. So most indictable crimes involving domestic violence make possession of a firearm a second degree crime with a 5-year minimum term of imprisonment under the Graves Act. So the consequences for violating these rules are very steep in New Jersey. Now, the last way to remove a firearm from an abuser in New Jersey is the ERPO, the Extreme Risk Protective Order Act of 2018. You can tell from the date this is a fairly recent addition to the safety net that exists in New Jersey to keep victims safe. So under ERPO, people who can be prohibited from possessing firearms are anyone who presents a significant danger of bodily injury to themselves, which is a distinction from what we talked about before. So to themselves or others by possessing or purchasing a firearm. So ERPO can be used to prevent somebody from getting a firearm if they present a significant danger of bodily injury to themselves or someone else by the possession of that firearm. How do you apply for that? So people who can file for an ERPO is broader than with a restraining order. In domestic violence, it had to be a family or household member, a spouse or former spouse, present or former household member, current or former dating partner. They have or will have a child in common. This is broader in the ERPO context. All those same people can do it, but also a law enforcement officer can do it. So, for example, neighbors, friends, anyone who does not qualify as a family or household member, um, but still knows that somebody presents a danger to him or herself or others by the possession of firearms, they can bring that information to law enforcement, and law enforcement officers can file for the ERPO. Here is the distinction. So, like I said, I mean, everything in domestic violence still applies here. It's broader. ERPO is broader. So in domestic violence, it's a limited number, limited subset of people who can apply for the restraining order. In ERPO, law enforcement officers can too. In domestic violence restraining order context, there has to be an act of domestic violence. That's not the case in ERPO. So there can be a risk, a foreseeable risk of criminal act, but no actual commission of a criminal act is required to bar somebody from possessing firearms under ERPO. And the standard for DV is a need to protect a victim's well-being, and it's different in the ERPO. In ERPO, it's an immediate and present danger of bodily injury to self or others by possessing or purchasing a firearm. So this one of the most effective things ERPO has accomplished in New Jersey is to prevent suicides by way of firearms, which obviously is not something that a restraining order addresses. All right, so the petition, how one goes about applying for an ERPO. The ERPO petition can be filed at the Superior Court or state, county, or municipal law enforcement agency. It's entered through ECDR, so it's not something that can be done anywhere. It has to be entered by either a court or law enforcement agency staff. It's not a system that's available to everybody. They have to go to the right place. And it must be filed in the same county where the respondent resides. And respondent is the person who presents the immediate and present danger of bodily injury to self or others by possessing or purchasing a firearm. So the person who's at risk of hurting him or herself or others by possessing the firearm, that person's county of residence is where the ERPO has to be filed. Now, what's included in the petition? It's going to include an allegation that the respondent poses an immediate and present danger of bodily injury to self or others by possessing, purchasing, owning, or receiving a firearm. It's going to set forth the facts and how those facts are known so that the judge reviewing this application knows where the information is coming from. And then it's going to include a description of the firearms believed present so that if it's granted, law enforcement officers know what to seize. Now, law enforcement officers do not have to be the ones to file for an ERPO, but they can. And there are 3 circumstances where they can become involved. They shall file the petition if there's probable cause to believe that the respondent poses an immediate and present danger of causing bodily injury to self or others by owning, possessing, purchasing, or receiving a firearm. They shall take over a petition if all those conditions are met, and it would be best filed by a law enforcement officer, or it can only be filed by a law enforcement officer. So, for example, information provided by a neighbor that supports probable cause, but the neighbor is not somebody who can actually file for the ERPO. So in that case, the law enforcement officer shall take over the petition. And they may file or take over or join a petition and any other circumstances in the officer's discretion, as long as there is good cause to believe that respondent poses an immediate and present danger of causing bodily injury to self or others by owning, possessing, purchasing, or receiving a firearm. If there is a search warrant issued in connection with the ERPO to search for and seize weapons, there has to be an establishment of probable cause, just like we mentioned with the restraining order. But if probable cause is established, the law enforcement agency where that respondent resides shall execute immediately or as soon as possible to remove those firearms. Now, what are the courts going to look like? What are they going to look for in deciding whether to issue this? And I maybe should have mentioned this earlier, but ERPO is also a 2-step process, similar to a restraining order where there's a temporary restraining order that's one side presenting, and then there's a final restraining order where both sides come and a respondent has an opportunity, or a defendant has an opportunity to defend him or herself. That's a similar model to how the ERPA works. So first, there's a temporary extreme risk protection order that's applied for. And then there's a subsequent hearing for a final extreme risk protection order. So obtaining a temporary extreme risk protection order, the court is going to look at the ERPO factors, which there's a number of them, and I'm going to get to them in just a second. So the court is going to consider the ERPO factors. They're going to have the standard of review of whether there is good cause to believe that the respondent poses an immediate and present danger of causing bodily injury to the respondent or others by having custody or control of owning, possessing, purchasing, or receiving a firearm. And like I said before, the standard of search warrant is probable cause. So let's talk about the ERPO factors. So the ERPO factors that the court is going to look to is whether there is a history of threats or acts of violence directed towards self or others. Whether there's a history of use, attempted use, or threatened use of physical force against another person. Whether the subject has violated a TRO or a restraining order issued under the Prevention of Domestic Violence Act, whether the subject has violated a temporary or final order issued pursuant to the Sexual Assault Survivor Protection Act, any prior arrests, pending charges, or convictions for a violent, indictable crime or disorderly persons offense, stalking offense, or domestic violence offense, any prior arrests, pending charges, or convictions for any offense involving cruelty to animals, or any history of acts involving cruelty to animals, any history of drug or alcohol abuse and recovery from the abuse, recently acquired firearm, ammunition, or other deadly weapon, whether there's a history or whether there was reckless use, display, or brandishing of a firearm, whether there are existing or previous ERPOs issued against this individual, and whether the individual previously violated an ERPO issued against him or her. Now, if the court finds one or more of those factors, then the court may also consider these factors, whether there's any prior involuntary commitment in a hospital or treatment facility for persons with psychiatric disabilities, whether the individual received or is receiving mental health treatment, whether the individual complied or has failed to comply with any mental health treatment, and finally, whether the individual received a diagnosis of a mental health disorder. So, TERPO, the temporary extreme risk protection order, is heard in an expedited manner. The venue which is where the case is heard, is in the county where the respondent lives, unless the respondent lives out of state. Then the venue would be filed where the petitioner lives. The court for the TERPO phase may examine the petitioner or rely on an affidavit. And at this phase, generally, there's no respondent appearance. So the person that either an individual or law enforcement is trying to prevent from acquiring firearms, that person is usually not there for the TERPO phase. And there's no requirement for law enforcement officers or prosecutors to be present at this phase unless law enforcement is the petitioner. Now, in contrast, the final extreme risk protection order is generally supposed to be scheduled within 10 days of the TERPO, unless there's adjournments for some reason or another. The respondent has the right to be present and present documents and witnesses. Again, when deciding whether or not to issue a FERPO, the court is going to look to the factors that we discussed above. And the standard is higher. It's whether by a preponderance of the evidence, not just good cause, a preponderance of the evidence at the hearing, more likely than not, the respondent poses a significant danger of bodily injury to the respondent, self, or others by having custody or control of owning, possessing, purchasing, or receiving a firearm. At the FERPO phase, prosecutor only has to appear if law enforcement is the petitioner. Either they were the one who originated the petition, they took it over, or they joined it. And if there was no search warrant issued after the TERPO was issued, a court could still issue that at the FERPO phase in accordance with the final extreme risk protection order. Now, there are criminal consequences for possessing a firearm when there is an ERPO in effect in New Jersey. And it is also a disqualifying factor in general. So any person who is subject to a court order prohibiting the custody, control, ownership, purchase, possession, or receipt of a firearm or ammunition issued pursuant to the Extreme Risk Protective Order Act of 2018 is a listed category of an individual who cannot obtain a firearms ID card or permit to carry in New Jersey. But then in terms of criminal liability, they are also a certain person not to possess a firearm. So specifically, a person who is subject to a court order prohibiting the custody, control, ownership, purchase, possession, or receipt of a firearm or ammunition issued pursuant to the Extreme Risk Protection Order Act of 2018, who purchases, acquires, owns, possesses, or controls a firearm or ammunition is guilty of a crime of the third degree. So they're looking at criminal charges, somebody who has an ERPO in effect and possesses firearms anyway. Now, this is different from the domestic violence setting that I talked about before, though, because violation of this statute is not a graves offense. So while possessing a firearm after being convicted of a domestic violence simple assault is a third degree crime with a 42-month minimum term of imprisonment, there is no presumption of imprisonment when somebody possesses a firearm in violation of an ERPO. It is a third degree crime, so that individual faces the possible prison sentence of 3 years to 5 years. But if there's no criminal history, there's a good chance that individual will get probation. But either way, the criminal consequences are significant when somebody possesses a firearm in New Jersey in violation of the statutes put in place to keep people safe. And that's it. Any closing comments, Michelle?
No, just keep in mind that there are several avenues for anyone who is concerned about the possession of a weapon by somebody who is either a domestic violence abuser or is a threat to themselves.
Thank you.
Thank you so much.
Hello, everyone. My name is C.A.R.E.S. I'm an assistant prosecutor at the Union County Prosecutor's Office assigned to the Domestic Violence Unit. Our next speaker is going to be Dr. Doreen Dojan McGee. We're so honored to have a survivor's voice joining us as part of this year's program. Dr. Doreen's sister-in-law, Laura, and her three nieces, Sarah, age 5, Rachel, age 3, and April, 6 months old, were all shot and killed by Laura's husband, their father, on September 11th, 1995. Doreen is a psychologist, author, and speaker who focuses on how technology shapes people. Far from technology averse, her research centers on moderation with technology use alongside an intentionally rich embodied life. Her book, Deviced: Balancing Life and Technology in a Digital Age, was awarded the 2018 Gold Nautilus Award for Psychology and has been featured in the New York Times, Time Magazine, and the Washington Post. Doreen is a celebrated podcast guest with appearances, among others, on Getting Curious with Jonathan Van Ness and PRI's Innovation Hub. Her new book is Restart: Designing a Healthy Post-Pandemic Life. Thank you for joining us, Doreen.
Thank you so much for spending your day as you have today. My name is Doreen Dojan McGee, and I'm a psychologist, mother, activist, friend, and auntie. My sister-in-law, Laura, made me an aunt on Valentine's Day, which is my favorite day of the year. In the following years, she added 2 to my quiver of nieces, and I loved celebrating the mundane and monumental moments of life with my 3 nieces, especially after moving my sister-in-law and them out of their home and away from her abusive husband and their abusive father. She came to live with my mother-in-law and had a restraining order against him. The night before my eldest niece's first day of kindergarten, I hosted a backpack packing party where we stuffed her book bag full of love notes and school supplies. I had no idea that it would be the last time I would get to pour Auntie love all over all of them. The next day, angry over missing the excitement of the first day of school, my brother-in-law purchased a gun, shot his way into my mother-in-law's home, and shot and killed Laura, Sarah, Rachel, and April. Sarah was 5 years old. Rachel was 3 years old. And April was only 5 months old. My mother-in-law witnessed the murders, was shot, but survived, and I became her caregiver for the rest of her life. The trauma that she and the small community where this occurred endured was unspeakable. For a long time, I didn't tell our story because I thought it was just that, our story. Horrifically, however, I have learned that our story is America's story. More than half of all mass shootings in the US are domestic violence related. Countless women like Laura do all that they can to protect their children and can't because of easy access to firearms, even when restraining orders are in place. As you learn of my 4 family members taken by gun, and my mother-in-law, and Sarah's kindergarten classmates, some of whom witnessed the scene, I implore you to knit your heart to their hearts, to determine to do whatever is your part to do to end the horror and trauma that gun violence inflicts upon not only the family members of those taken, but also the communities that they live in. My nieces had classmates and neighbors, piano teachers, dance instructors, Sunday school teachers, and friends who loved them just as much as this auntie did. And none of us will ever be the same. Thank you for dedicating your day to informing yourself. Now it's time to get active. Join me in honoring the countless women and children who no longer have voices, in using your voice loudly and consistently in our fight to end gun violence and domestic violence. For Laura, Sarah, Rachel, and April, and the nearly 70 women killed every month by gun, step up and step out. For all of us and all of you, never give up.
I want to thank all our speakers today for their informative and impactful presentations. I also want to thank everyone that joined us today for this amazing event. I'd especially like to thank the Union County chapter of Moms Demand Action, specifically Kathleen Dolan, for securing our keynote speaker. Please give us your feedback and complete the survey at the end of this event. This will help us plan future symposiums. If you're applying for CEUs or CLEs, you must complete the survey to receive your credits. This event has been recorded and will be on the YWCA YouTube channel for further viewing, or if you want to share with your colleagues. Thank you again. If you are in need of help, please call our domestic violence hotline at 908-355-4357. To learn more about the YWCA Union County, please visit our website at www.ywcaunioncounty.org. Thank you.